Federal Appeals Court issues a stay on the Biden administration's COVID-19 vaccine mandate, which was put in place for companies with 100 or more employees. More than 24 states have filed lawsuits against the rules that were laid out by the Occupational Safety and Health Administration, also known as OSHA, citing grave statutory and constitutional issues. And joining me now is Ken Cuccinelli, Senior Fellow for Immigration and Homeland Security at the Center for Renewing America and former Attorney General of Virginia. Ken, welcome back. Great to see you. The stay issued for the vaccine mandate, as we know, is only temporary, but it is being considered a victory by many. Can you talk to us more about that and exactly what the ruling means?
Sure. So the Fifth Circuit, one of the federal courts of appeals, stayed the private vaccine mandate. So if you think about three different mandates, there's one for federal employees. That's its own category. There's one for federal contractors. The federal government is achieving that by changing the contract provisions that they engage with these companies with. And then this third one is the biggest one of all. It's a mandate on all companies of 100 people or more to vaccinate all their employees. They're doing it by a regulation out of the Labor Department. And to say it's an ill fit is probably an understatement. So to get a temporary injunction, as the plaintiffs did here, one of the things they have to demonstrate to the court is that they are likely to win on the merits when the case is fully heard out. And I think that that's such a strong case. There's so little authority for the federal government to attempt to force these mandates that it wasn't a tough call for the court. But as you said, it is temporary. There will be another round where this will get revisited and the government will try to explain what their legal basis is for being able to order all these companies to do this. And but we'll see where it plays out. Presumably, ultimately, it'll go to the Supreme Court. Nonetheless, for now, it's a nationwide injunction.
Now, Ken, what exactly does that mean, grave statutory and constitutional concerns? Can you break that down for those who may not understand it?
Sure. So you've seen just in the COVID situation we've lived with almost 2 years now, states have taken the lead on making orders for their communities, whether it's you must wear a mask in a restaurant or a school or vaccinations. These are all traditionally what are called police powers. Don't mistake it for cops on the beat. Police powers are things like public health, zoning, local authorities. These have always been exercised by the state governments, and the Supreme Court has recognized their authority to do that as a sovereign state. The federal government has never been deemed to have any of this power. So here they are exercising what amounts to a traditional state police power under a labor safety regulation that really doesn't fit the situation very well and has never been used for anything like this. So the constitutional power grab by the federal government is taking this police power from the states. That's one. And two, the statutory problem they have is that the law that gives the Labor Department the authority to make regulations for workplace safety doesn't really cover this situation in the way the White House is trying to convince people it does. Of course, the court was not convinced, and so they imposed the injunction. I expect this regulation, I do not think is going to hold up. It's the weakest of the three categories that the federal government is attempting to force people through. And I don't think you're ever going to see this injunction come off because the government's going to lose this case.
Okay, and thank you so much for your time. So much more we could talk about, but we're running out of time. We appreciate your analysis.
Good to be with you.